You sit in the waiting room of the U.S. Embassy. You have been waiting for this interview for 2 years. You practiced every answer. You brought every document. You paid every fee. The officer calls your name. You walk in. The interview goes well. He stamps your file. He tells you everything looks good. Then he says 5 words that will haunt you for months. We cannot issue today. You ask why. He says there is a hold on your country. You ask how long. He says he does not know. You walk out of that embassy without a visa, without an explanation, and without any idea when or whether that door will ever open again. Your spouse is in America. Your children have been separated from you for years, and somewhere in Washington, buried inside a footnote that no news channel bothered to read, is the reason your life just stopped. My name is James. I am a senior immigration analyst with 6 years of federal policy experience. On Immigration News Today, I do not give you opinions. I give you the law, the loopholes, and the survival strategies that keep families together. I am not your attorney. This is educational information only. For your specific case, consult a licensed immigration lawyer. Now here is what USCIS is counting on you not knowing. On January 20, 2026, the Trump administration issued a presidential proclamation that triggered an indefinite pause on immigrant visa issuance for nationals of 75 countries. The countries affected include Pakistan, Bangladesh, Egypt, Russia, Cuba, Haiti, and dozens of others spanning South Asia, the Middle East, Africa, Eastern Europe, and the Caribbean. The pause is not a ban in the traditional legal sense. Consular officers are still scheduling and conducting immigrant visa interviews. The State Department is still collecting fees. USCIS is still approving I-130 petitions and sending cases to the National Visa Center. Everything looks normal from the outside. But at the final step, the moment when the officer would stamp your visa and hand it back to you, a system-level hold prevents issuance. The visa is approved in substance but frozen in delivery. And the legal mechanism enabling this freeze is buried in what State Department insiders have been calling Footnote D, a directive attached to a cable sent to all U.S. embassies and consulates on January 21, 2026, the day after the proclamation was signed. But here is the trapdoor most people fall through. Because the freeze is not announced as a ban, and because interviews are still happening, tens of thousands of applicants from affected countries have continued spending money on medical exams, document translations, travel to consular posts, and legal fees without knowing that issuance is frozen at the final stage. Families are flying from Pakistan to their nearest U.S. consulate in a third country, paying thousands of dollars for the appointment, sitting through the interview, and then being told their visa cannot be issued due to administrative processing. Administrative processing is the official language being used to describe what is, in practice, a policy hold with no defined end date. And the legal authority being cited for this action comes from INA Section 212F, which gives the President broad power to suspend entry of any class of aliens when their entry is deemed detrimental to the national interest. This is the same statutory authority used in the 2017 travel ban that the Supreme Court upheld in Trump v. Hawaii, 585 U.S. 667, decided in 2018. In that decision, the court held that Section 2.12F grants the President nearly unchecked discretion over entry restrictions, provided the order includes a finding of national interest harm. The January 2026 proclamation includes such a finding, tied specifically to what the administration describes as deficiencies in identity verification and public charge vetting systems in the 75 affected countries. That is the legal hook. And it is a strong one. Stop. Before you do anything else, write this down. The freeze is officially connected to a public charge and document integrity review, not to any criminal or terrorism designation. This distinction matters enormously for 2 reasons. First, it means the freeze is theoretically temporary and tied to conditions that could be renegotiated or certified. Second, it means that applicants from affected countries who are already inside the United States on non-immigrant visas and are adjusting status through USCIS, rather than going through consular processing abroad, may not be affected by the same freeze. Adjustment of status under INA Section 245 is a domestic process handled entirely within the United States. The January 2026 proclamation, based on its current text, applies to consular processing and entry. This is a critical fork in the road that most people are missing entirely. Now let me tell you about Ahmed. He is an engineer from Egypt. He has been in the United States on an H-1B visa since 2019. His employer sponsored him for a green card. His I-140 petition was approved in 2022. His priority date became current in late 2025. He was scheduled for his immigrant visa interview at the U.S. Embassy in Cairo in February 2026 because his family circumstances required him to process abroad rather than adjust status domestically. He paid for his medical exam, compiled years of tax records, and flew back to Egypt with full confidence that he was weeks away from permanent residence. After his interview, he was told his case was in administrative processing with no timeline. His H-1B status in the United States expires in 6 months. He cannot re-enter on his immigrant visa because it has not been issued. He is now trapped in a legal limbo that the January proclamation created, holding an approved I-140, a current priority date, and a frozen visa, with a clock running down on his ability to return to the job and life he built over 6 years. Ahmed's situation is not unusual. It is the new normal for nationals of 75 countries. The silent killer in this freeze is hidden in the administrative processing designation itself. Under the Foreign Affairs Manual, specifically 9 FAM 504.11, consular officers have the authority to place cases in administrative processing when additional review is required before a visa can be issued. Historically, administrative processing lasted weeks to a few months and was used for individual security checks. What is happening now is that administrative processing is being used as a system-wide holding mechanism for an entire policy freeze. The practical consequence is that there is no individual review happening. These cases are not in line waiting to be cleared one by one. They are parked. And because administrative processing has no statutory deadline, there is no legal trigger that forces consular officers to act. Unless a court intervenes or the proclamation is modified, cases can sit in that status indefinitely. What I'm about to tell you contradicts what most lawyers say. Most attorneys advising clients affected by this freeze are recommending patience, monitoring the situation, and waiting for litigation outcomes. While that advice is understandable, it ignores one concrete option that remains open for a significant number of affected applicants. If you are currently inside the United States in valid non-immigrant status, and you have an approved I-140 with a current priority date, and you have not yet departed for consular processing, you should urgently discuss with an immigration attorney whether you qualify to file for adjustment of status on Form I-485. Adjustment of status keeps your case inside the United States and inside the USCIS domestic system, which, as of today, is not subject to the same freeze as consular processing abroad. Once you depart the United States and attempt to process your immigrant visa at a consulate in an affected country, you may lose this option entirely. Departure and reapplication through consular processing for nationals of the 75 listed countries is, right now, a one-way door into the freeze. There is a 72-hour window. Miss it, and this option disappears forever. If you are currently in the U.S. on H-1B, L-1, or another valid non-immigrant status, and you have an approved I-140, and you are considering traveling internationally before filing your I-485, stop that travel immediately until you have spoken to a licensed immigration attorney about the implications of the January 2026 proclamation on your specific case. Travel abroad followed by attempted return on a frozen immigrant visa could result in your being stranded outside the United States with no clear path to re-entry. Here is your action plan starting right now. Tonight, confirm whether your country of birth appears on the 75-country list affected by the January 2026 proclamation. Country of birth, not citizenship, is the determining factor for most immigrant visa categories. If your country of birth is on that list, and you have a pending or approved immigrant visa case at a U.S. consulate abroad, contact your attorney tomorrow and request a status review specifically asking about adjustment of status eligibility. If your case is at the National Visa Center and has not yet been sent to a consulate for interview scheduling, ask your attorney whether you can request a change of venue to a domestic adjustment of status filing if you are currently inside the United States. If you have already attended your interview and are sitting in administrative processing, document every communication you have received from the consulate, every fee receipt, and every date, because litigation in this area is moving quickly, and detailed records will matter when the legal challenges to this freeze reach federal court. Finally, monitor the docket in the case Iranian American Bar Association versus Trump, as well as any new filings in the Ninth and Fourth Circuits, where challenges to executive entry restrictions have historically found the most traction. Immigration rules change overnight. One executive order, one court ruling, and everything shifts. I send urgent alerts to my WhatsApp community before I even post on YouTube. The link is in the description and pinned comment. Join now. It is free, and it could save your case. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. I am James. Protect your status. Protect your family. I will see you in the next update.